Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 11 and 12 on the speed of 90 words per minute. Start. The first relief claimed by the plaintiffs in the suit is a decree for declaration that the reconstituted partnership deed dated 17 to 1992 was illegal and void, and there was no intention or desire of Sri Rajendra Prasad Singh to retire from the partnership, and further that the plaintiffs, being heirs of Sri Rajendra Prasad Singh, will be deemed to be continuing as partners to the extent of his share. It is true that the plaintiffs have also sought rendition of accounts and their share of profits from the partnership, as well as interest over the unsecured loan and the principal amount of unsecured loan on rendition of accounts. For getting this relief, the plaintiffs undoubtedly rely upon the partnership deed dated 13/1/1989. However, this deed of 1989 could be relied upon and form the basis of the claim of the plaintiffs only if the partnership deed dated 17 to 1992 was declared as void. If the dated 17 to 1992 was not declared as void and remained valid and operative, the plaintiffs could not fall back upon the earlier partnership deed dated 13/1/1989 to claim rendition of accounts and their share of profits. Therefore, in order to get their share of profits from the partnership business, it was absolutely essential for the plaintiff appellants to have partnership deed dated 17 to 1992 declared as illegal, void, and inoperative. The relief for such a declaration could only be granted by the civil court and not by an arbitrator, as they or Sri Rajendra Prasad Singh, through whom the plaintiffs derived the title, are not party to the said deed. The trial court had, therefore, rightly held that the matter could not be referred to arbitration, and the view to the contrary taken by the High Court is clearly illegal. Subsection 2 of Section 8 of the 1996 Act says that the application referred to in subsection 1 shall not be entertained unless it is accompanied by the original arbitration agreement or a duly certified copy thereof. As already stated in the earlier part of the judgment, defendant number 3 had moved an applicant on 25/11/2004 under Section 34 of the Arbitration Act 1940 for staying the proceedings of the title suit and for referring the matter to arbitration. He filed a supplementary petition to the aforesaid application on 16/12/2004. Herein also reference was made to Section 34 of Arbitration Act 1940. Thereafter, he filed an application on 28/2/2005 praying that as the Arbitration Act 1940 had been repealed and the suit is of 1998, to avoid any confusion, his earlier petitions may be treated to have been filed under Section 8 of the Arbitration Act 1996. None of these petitions were accompanied by the original arbitration agreement dated 17 to 1992 or a duly certified copy thereof. In fact, there is no requirement of filing the original arbitration agreement or a duly certified copy thereof under Section 34 of Arbitration Act 1940, and as such there was no occasion for defendant number 3 to file the aforesaid document. Relying on the above said order, learned counsel for the appellant submits that respondent state ought to get first the order dated 10/3/2016 granting bail to appellant cancelled before seeking custody of the appellant. It may be true that by mere addition of an offence in a criminal case in which accused is bailed out, investigating authorities itself may not proceed to arrest the accused and need to obtain an order from the court which has released the accused on the bail. It is also open for the accused who is already on bail and with regard to whom serious offences have been added to apply for bail in respect of new offences added, and the court after applying the mind may either refuse the bail or grant the bail with regard to new offences. In a case, bail application of the accused for newly added offences is rejected, the accused can very well be arrested. In all cases where accused is bailed out under orders of the court and new offences are added including offences of serious nature, it is not necessary that in all cases earlier bail should be cancelled by the court before granting permission to arrest an accused on the basis of new offences. The power under sections 437(5) and 439(2) are wide powers granted to the court by the legislature, under which court can permit an accused to be arrested and commit him to custody without even cancelling the bail with regard to earlier offences. Sections 437(5) and 439(2) cannot be read into restricted manner that order for arresting the accused and commit him to custody can only be passed by the court after cancelling the earlier bail. Coming back to the present case, the appellant was already into jail custody with regard to another case, and the investigating agency applied before Special Judge NIA Court to grant production warrant to produce the accused before the court. The special judge, having accepted the prayer of grant of production warrant, the accused was produced before the court on 26/6/2018 and remanded to custody. Thus, in the present case, production of the accused was with the permission of the court. Thus, the present is not a case where investigating agency itself has taken into custody the appellant after addition of new offences. Rather, accused was produced in the court in pursuance of production warrant obtained from the court by investigating agency. We thus do not find any error in the procedure which was adopted by the special judge NIA court with regard to production of appellant before the court. In the facts of the present case, it was not necessary for the special judge to pass an order cancelling the bail dated 10/3/2016 granted to the appellant before permitting the accused appellant to be produced before it or remanding him to the judicial custody. In view of the foregoing discussions, we arrive at the conclusions in respect of a circumstance where, after grant of bail to an accused, further cognizable and non-bailable offences are added.